in the last 20 days where the breach of privilege is being used by such attack by the legislature was the Delhi Assembly. It issued a notice of breach of privilege to Facebook. And why did it issue notice to Facebook? What was the breach of privilege that Facebook is supposed to have done to the legislature? According to the Delhi Assembly, Facebook got published various articles on its pages, web pages, which created, according to the Delhi Legislative Assembly, an atmosphere that aggravated riots in Delhi. Facebook, of course, said we had nothing to do with what our members wrote on their web pages, and moved the Honorable Supreme Court seeking a stay of the notice served by the Delhi Legislative Assembly. The Honorable Supreme Court granted a stay and directed Facebook to respond to the notice and come back after looking at the manner in which the Delhi Legislative Assembly or legislature reacted. The second instance of interest was a 60-page notice sent to the Republic TV channel and its editor by the legislature of Maharashtra. That the notice has been served. Further than that of that notice, so we leave it at that, only it being a historical fact that the legislature has taken steps. A few days ago, I read in the newspapers that a leading film actor of the Indian film's screen has also been a target of the legislature with a notice. I do not know if such a notice has been actually issued, but I read it in the newspaper, so it is just a contemporaneous bit of news for us. Lastly, if you are watching television news regularly, the government of India introduced 3 farm bills in Parliament. According to the government, these farm bills were of immense reformist kind of an action, and therefore when the government introduced the farm bills, suddenly we found a ruckus in Parliament, so much so that in the upper house of the Indian legislature of Parliament, that is the Rajya Sabha, we had members walking up to the podium, one of them dancing on a table in front of the chairperson of the Rajya Sabha, another one tearing up the rule book and inviting the Rajya Sabha to invoke its rules to get them suspended. Very shortly, I'm very sure that the Rajya Sabha would be issuing breach of privilege notices to these members, and again we would be back to know what is going to be the consequence of such an action. These are the 4 events that happened in the last 20 days. But by and by, over the years, breach of privilege has been, and motions following that breaches from the legislature have been making news. One of another notable action was against editor or contributor to newspapers by a noted journalist by name of Shobha De. What did she do? The Maharashtra government took a decision to force theatres in Mumbai and other places to display and show Marathi films at prime times, as against Hindi films, which really brought in money for the theatres. When Shobha De wrote an article that instead of popcorn and coke, I would have to eat vada pav and dhahi misal, some legislatures took offence and issued her a breach of privilege notice. So that was the level to which our legislators have gone to hit back at somebody who criticized them. Therefore, this issue becomes very relevant for you. And at the end of this small discourse that I'm going to give you, I would be making you wise enough to decide whether the notices issued to Facebook, the notices issued to Republic TV and its editor, the notice that probably might be issued to the actor, and to follow what steps the Rajya Sabha chairperson would take against those of the members of parliament who are said to be the elders of the legislature of parliament. What is going to be their fate? You would be wise enough to decide, and for yourself at the end of this discourse of mine, this lecture of mine, I hope it would help you to elucidate, to clear yourself of the legal aspects of the privilege motions. Okay, now let me get started. What happens is that the kind of the parliamentary system that India has is what we call as the federal system. India has adopted consciously the federal system in contradiction to the parliamentary sovereignty which is prevalent in Britain, in the sense that in Britain, parliament is the dominant body. In India, we don't have the House of Commons as a dominant body, that is the Lok Sabha as the dominant body, but our federal system, as you all know, has three arms: the legislature, the executive, and the judiciary. The power for all these three arms flows from the Constitution of India. That is where the power comes in. Therefore, in a federal system, each of the functions of the three arms have their primacy in their particular functions. For instance, Parliament or the state, that is the state legislature, has to specialize in is given the work of making laws of the country. The executive's job, that is the government's job, is to enforce those laws. It has to check on how the laws are functioning, how the citizens are going to benefit by the laws. And third, the third arm, that is the judiciary, it is the one that interprets the law, and it makes sure that nobody of the other two arms transgresses the limits to which they have been set, and therefore we have what is called as something as the judicial review, which has been by the Keshavananda Bharati case in 1973, has described it as one of the basic features of the Constitution of India. So the powers that emanate from the Constitution are shared by these three bodies, that is the legislature, the executive, the judiciary. Each one has a primacy in its own right. Each one will have the right to make sure that its functioning is largely to the effect and to the benefit of the citizens of India. Now, when we talk about the functions of the state, we have to look at how does each one of these bodies function. Now, for instance, when we say that the judiciary has its own primacy, the Constitution gives powers to the Supreme Court of India, the High Court of India. You have the writ jurisdiction under Article 226. You have the writ jurisdiction under Article 32. The Constitution in Part 3 of the Constitution of India speaks of fundamental rights. Fundamental rights are sacrosanct, and they are the ones that are the heart and the soul of the entire liberty of a citizen. The fundamental rights protect the citizen utmost to make sure that he lives, or he or she lives and breathes what democracy really tries to give them the benefits under the Constitution. So therefore, the fundamental rights are in Part 3 of the Constitution. Then you have Part 4, which are the directive principles of state policy. And so therefore, the Constitution is where the Supreme Court derives its strengths to make sure that not only citizens enjoy their democratic rights, but the other two arms, the executive, the legislature, function within the parameters allocated to them. We now go straight to the legislatures, which has two houses, the Lok Sabha and the Rajya Sabha. You have the state legislatures, which has the assemblies, and that is the legislative assembly and the council. There are some states that do not have the legislative council, but majoritarily, most states in India have the legislative assembly. Now, the legislature is supposed functionally to make laws, to administer laws, and make sure that the citizens whom the legislators represent function in a manner so that such citizens and the districts which they represent get fair hearing and their grievances are taken care of. Now you have the legislature which is vested with certain rights. We are dealing with those rights today, and these rights are what you call as the privileges or the powers and the immunities that the Constitution has granted to the legislatures. Now, what are the privileges that we are talking about? Now, if one sees what privileges mean, in the UP Assembly case, which facts I shall be adverting to very shortly, the judgment of the Honorable Supreme Court in AIR 65 Supreme Court page 745, it is called as the special reference 1 of 64 and the Keshav Singh case. In that, at paragraph 70, the Honorable Supreme Court has stated what a privilege means. It says, parliamentary privilege is the sum of peculiar rights enjoyed by each house collectively. Correct? So, enjoyed by each house collectively as a constituent part of the High Court of Parliament and by members of each house individually. So, privileges that are conferred upon the legislature are of two kinds. One is the House collectively enjoys privileges, which the individual members of Parliament or the members of the legislative enjoy individually. The House, which the individual members enjoy functions, and those possessed by other bodies enjoy individually or individuals. So, there are privileges enjoyed by the House collectively. For instance, I abuse and say detrimental things to the Maharashtra Legislative Assembly in a business that it's transacting. The Assembly can take cognizance of that, and the Assembly or the House as in collectively can punish me or issue a breach of privilege notice to me and then take punitive action if the situation so requires. Then you have members individually who are also given rights or privileges by Parliament. And these privileges are because without these privileges, the House or the members cannot discharge their functions effectively. And these privileges are the ones which exceed those possessed by other bodies and individuals. When the House collectively and the members individually are granted privileges, these privileges are in excess of the normal privileges that individuals or bodies get benefit of. And further, the definition says, thus privilege, though part of the law of the land, is to a certain extent an exemption from the ordinary law. The particular privileges of Commons have defined so and so. Right? Now they go into the definition of the House of Commons, and it says the sum of fundamental rights of the House and of the individual members against prerogatives of the Crown, the authority of the ordinary courts of law, and the special rights of the House of Lords. We needn't go into the House of Commons and their rights, but as far as privileges are concerned, the definition is very clear. There are two kinds of privileges, one collectively of the entire House and of the members individually, of which the members enjoy. And these privileges are meant to really ensure that the Parliament functions in the way that it should be. It should function without any interference, without any kind of an impediment, or without any kind of an obstruction, so that Parliament can function without any, or the members can function in a way that there are no impediments. So that is a privilege conferred upon the members of the Legislative Assembly. Now, we shall go into what are the privileges that have been conferred really to understand. Now, if you see, when they say that you have privileges which are enjoyed by the House collectively, it would mean that it would mean to exclusively regulate the affairs of the Legislative Assembly. For instance, the power to regulate debate, the power to fix a time for discussion of certain events, time for discussing the budget, and a time for I don't know if you've been reading your newspapers and watching television. Because of the COVID-19 and the pandemic situations, the Minister of for Parliamentary Affairs decided that 0 hour in the Parliament would be suspended for this particular session. There was a furor, and they said that no, 0 hour is sacrosanct, it's so important, etc., etc. But that's an internal power of the House, which it has. The House collectively regulates its own business. That being the regulatory part of its powers, the House also has a power to punish a person which is guilty of the breach of privilege. The House collectively has a power to haul a person for contempt committed against a privilege that is conferred upon the House. The House has a right also to determine what, by the rule-making power that is given to it, to determine the quantum of punishment for a particular person who commits a breach of the privilege of the House. And apart from these rights, the House also has a right to carry out administrative actions, like in a breach of privilege case, it can form a committee. A committee can question the person who has committed a breach. The committee can cross-examine such persons. The committee can come to a conclusion, make a report, submit it to the speaker or to the chairman of the Rajya Sabha, or in the Legislative Assembly, again, make a report to the speaker and advise the speaker as to what it has decided about the quantum of punishment to be given to a person who commits a breach of the privilege. So that is the collective responsibility of the House, or the what it regulates as its business. In contrasting distinction to that, you have powers of members individually. For instance, under Article 184 and for Parliament, and Article 105 for Parliament and 184 for the Assembly, members individually have the freedom of speech and expression, the freedom from arrest in any civil action, exemption from attending court, freedom from obstruction, interference, intimidation, molestation in the course of carrying on their work as a member of the Legislative Assembly. And under Section 135A of the Civil Procedure Code, the member of the Legislative Assembly cannot be arrested 40 days before the session, the Legislative Assembly session, during the period of the session, and 40 days after the Legislative Assembly session comes to an end. So these are privileges. Now, we shall go into each of these individual freedoms and even the collective freedoms. And wherever courts have dealt with such kind of freedoms, I shall be dealing with those specific judgments to elucidate and make clear for you what the freedom means. Right? Now, let me go to another important aspect of the privilege, in the sense that how did this freedom, the privilege come about into the Constitution? historically, what has happened for us to know about the privileges that we enjoy today. Now, breach of privilege is a subject that has been existing long, for over maybe thousands of years. Like, for instance, the earliest case that I could lay my hands was of the year 1452, where in the British Parliament there was an issue of a breach of privilege, and a debate took place as to the rights of the members against that breach. I shall come to the case law a little later, but just to give you an idea how the articles on the privilege entered into our constitution, historically what happened. For the first time in the year 1784, under the East India Company Act, the aspect of breach of privilege was dealt with under that act in 1784. In 1833, under the Charter Act, CHATER, the Charter Act, it provided for a legislative authority, and in the name of the Governor General's Council, there was an authority. Now, the Governor General's Council was had two functions. One, it was managing or governing the country, and apart from the Governor General's Council, which comprised of very elitist and respectable members, there were also meetings of a council for discharging other jobs. Now, what I'm trying to arrive at, and by showing you this, is that in the Governor General's Council, there were already a dichotomy of functions. One function was of the Governor General's Council was for lawmaking. It would make laws, which our legislatures even today make laws. Apart from making laws, there were meetings of the council which were dealing with other aspects of the rights of the members, what topics had to be discussed, etc. Now, this Charter Act underwent several amendments, and the last of them came around in the year 1861. Then came in 1915 the Government of India Act, which was a precursor to the Government of India Act of 1935. In the Government of India Act of 1915, for the first time, there was in the office of the Governor General of the Governor General's Council, a Council of States and a Legislative Assembly. The Council of States was purely to make laws, while the Legislative Assembly carried on the other businesses apart from making laws, that is, administering the country. In 1919, we had the Government of India Act with an amendment, and what the 1919 Act did was that it brought in certain rules which gave certain privileges to the Governor General's Council. This aspect of privileges were in the form of two privileges. The first one was there was a freedom from any kind of arrest to the members of the Governor General's Council, and the second privilege was that they were exempt from jury service. Now, please remember, there was a jury system prevalent all over England and also in India for trials in courts. So the Governor General's Council members were exempted from those two and were given those two privileges. Now, the Legislative Council members were members who were nominated or elected under the Government of India Act 1915. So you had nominated members and elected members. Just like you have in the Rajya Sabha even today, you have members who are elected. So these members get elected by MLAs from the state, and you have nominated members whose tenure is for a period of 2 years. So you have eminent jurists, you have film actors who are all nominated to the Rajya Sabha to subserve their particular industries or their vocations, etc. Then came the 1935 Act, Government of India Act, which most of us lawyers are familiar with. And in the Government of India Act, Section 71 brought for the first time more privileges, and those privileges were in the nature of freedom of speech for members of the Governor General's Council. They had also freedom of arrest, and that was the beginning of crystallization of the rights of members who served in legislatures. Now, please remember that there was a constituent assembly that came into being in the year 1937, and it was, of course, not parliament, but the constituent assembly largely devoted itself to governing India. We were in the throes of a freedom movement, a freedom struggle, and finally we had our constitution, which India became a republic in the year 1950. And in the drafting of the constitution, we found that there were two articles, Article 105 for Parliament and Article 184 for the legislatures, that is for the states. And just as a matter of for academic information, for drafting these particular articles, which was the aspect of privileges or powers and immunities that were granted to the legislatures, we had a committee formed which undertook the drafting. We had the chairman, Shri B.R. Ambedkar. There was Mr. Jaspat Roy Kapoor, Professor K.T. Shah, Mr. Shubham Lal Saxena, Mr. Nazir Ahmed, Mr. P.S. Deshmukh, Mr. Alladi Krishnaswamy Iyer, and Mr. H.V. Kamath. These were the persons who drafted the two articles on privileges to be granted and conferred to members of parliament and members of the legislative assembly. Now, this takes me to the two articles. Both articles are paramateria. They are identical and are similar in their effect and in their application to parliament and legislature. And I would be reading out to you Article 194, correct? Because this Article 194 has been a subject matter of several litigations, because these are this is the article where legislatures are granted their privileges. Legislators use these particular article to issue notice of privilege, and now these days at the drop of the hat, without understanding whether the privilege or the privileges granted by the constitution to the legislatures really stands violated or not. So therefore, here we go. Article 194, this is for the state legislature. Subject to the provision of the constitution and to the rules and the standing orders regulating the procedure of the legislature, there shall be freedom of speech in the legislature of every state. Now, there shall be a freedom of speech in the legislature of every state. Why is there a specific mention in Article 194 for a freedom of speech? You are already conferred a fundamental right under Article 19(1)(a) of the Constitution. Of course, subject to reasonable restrictions in Article 19(2). But there is a specific reason why under 194 the Constitution has ensured that there should be a freedom of speech in the legislature of every state. Then 2, no member of the legislature of a state shall be liable for any proceedings in court. Second privilege. First, there will be a freedom of speech. Second, no member shall be liable for any proceedings in any court in respect of anything said. So, if a member says anything in the course of an argument, in a course of debate, in a course of a meeting in the legislature, or any vote given by him in the legislature or any committee thereof, and no person shall be so liable in respect of a publication by or under the authority of a house of such legislature of any report, paper, votes, or proceedings. So, between 194 and 194(1) and 194(2), there are 3 privileges which the Constitution guarantees, or not guarantees, the Constitution confers upon the legislatures or members of parliament. First is freedom of speech. Second, they shall not be liable for anything in respect of anything said, whatever they say in the legislature, that is free from any liability, liability of proceedings in any court. If a member of a legislature says something in the assembly, even personally against you, and says A is a cheat, A is guilty of breach of trust, whatever, you cannot sue him in any court of law. Or if a legislature votes in a manner which he feels he can do so, you cannot sue him in any court of law, and you cannot make him liable for the manner in which he has voted. And thirdly, no member of the legislative assembly shall be liable for any publication by or under the authority of the House. So the House publishes reports of a particular proceeding, and if a publication is challenged because that publication says something which is not to your liking, there is a privilege granted to the such make him liable challenged because the publication by virtue of Article 194(2). So these are express powers granted to under 194(1) and 2. Then you have 194(3). 194(3) says that in other respects, the power, privileges, and immunities of the House of the legislatures of the state and of members of the committee of such legislatures shall be from time to time defined by the legislature by law, and so defined shall be of those of the House of Commons of the United Kingdom, etc. Now this was modified. If it was not defined in the 1978 amendment, the references to the House of Commons and the United Kingdom was removed, and it became more localized. And they said that whatever was prevailing prior to such an amendment would be applicable, but later on it would be subject to the rules that are made by a house, and if not by the rules, then the common law or the Constitution of India, etc. Then came, therefore, in other respects, the power privileges of the legislature be by members, by the legislature, by framing rules, etc. Then lastly, Rule 4 says the provisions of 1, 2, 3 above shall apply to in relation to persons who by virtue of this Constitution have the right to take and otherwise take part in the proceedings of the House or of any committee, etc. So these were the four rules under Article 184. Now we come to what is so important and specific about these privileges, and why these privileges day by day, more and more frequently, which legislators are using as of day at the drop of the hat. Now we have privileges. Let's get into the privileges that privilege specific. Now, for instance, if there is breach of a privilege by a person, I will give you an example of a matter which is currently pending in the Honorable Bombay High Court. I appeared for a gentleman who was a very honest, upright, a man with a tremendous track record of performance as a municipal commissioner of a very important corporation in the state of Maharashtra. What he did was, in the course of his job, it happened that he took action against certain illegal structures that belong to a distant or some relative of a member of the Legislative Assembly. This man was, in the course of his duty, forthright, resisted every kind of pressure, influence cast upon him, and undertook his job with all the force and might he could, and took whatever steps he was entitled to in law. Later on, a scheme was floated. Of course, the MLA obviously got upset and was looking for ways and means to take his revenge. And therefore, what the MLA did was, he waited and bided his time to hit back at this particular municipal commissioner. The government of India announced a scheme for housing of the poor, and those schemes had certain guidelines. Now, under that scheme, the municipal commissioner was entrusted with a job of submitting plans to the housing authority as to the number of the houses required, the strata of income for people, how many belong to the economically weak sections, how many belong to a slightly higher strata, how many could pay for their structures, etc. These plans had to be prepared overnight. The man sat and within a period of 15 days was the first in the entire state of Maharashtra to submit his plans. But the guidelines provided for a rule that before the plans could be submitted, the municipal commissioner or such authority who was to submit the plans was required to consult the elected representatives of that area. So you had about 20 corporators, you would have about 5 or 6 MLAs, you would have one single MP for that particular area. What the municipal commissioner did was, he did consult this particular MLA whose relatives' structures he damaged, and he sent his representatives to apprise him of the plans he was to submit. But he did consult the other MLAs, he did consult whoever was required to be consulted, and submitted the plans. This act, alleged by the hurt MLA that he did not consult him, was treated by the MLA as an insult to his persona. It was treated as a contempt by or an insult to him, and finally landed in the Legislative Assembly with a breach of privilege against the municipal commissioner. All right. So it, according to the MLA, it was a case for breach of privilege, and what followed was something was that unbelievable. Of course, prior to that, the breach of privilege went to the speaker. The speaker went through the material. He was wholly dissatisfied with the motion. He felt there was no breach of privilege. The speaker kept the privilege application or notice in abeyance. It caused the MLA to be infuriated. He perhaps canvassed. We do not know that. And a stage came a month later. The entire House unanimously passed the breach of privilege motion and the commissioner for as that he was guilty of breach of privilege. Outstanding example, really. But the matter was taken up in court. The Honorable Court adjourned the matter about at least on 20 different occasions. And finally, the Assembly summoned the commissioner. I was resisting that. I requested the court that hear my matter. Why should my commissioner go and get humiliated? We were given assurances in open court that nothing of humiliation would happen. It would only assuage the feelings of the House, that the commissioner must just go and stand there. It will be over in 2 minutes, and it would be a nature, some kind of a reprimand. But this is an instance of a breach of privilege. Leave that apart. Matter is still sub judice. The High Court was, of course, very fair to us. It kept the issue open. It said even if the commissioner went to the Assembly, we will still keep the issue open and we will see the matter on merits and then decide and pass orders. We said, all right. But this takes me to another important aspect. What is the procedure in Parliament or in an Assembly when a breach of privilege occurs? A member who feels aggrieved that his individual rights have been violated, or if the House collectively feels that its rights have been violated, would firstly issue a notice to the person who has allegedly committed a breach. The notice goes to the speaker. The speaker goes through the merits of the notice. If the speaker prima facie finds that there is a breach of privilege, he will or she will immediately call upon the person who has committed a breach and either place the matter before the House or even award punishment to that particular individual. Alternatively, if the speaker feels that there is something to be considered, then in that case, the speaker would refer the matter to a committee of members, which are about 15 in the assembly. In parliament, it's 15 in the Lok Sabha, and in the Rajya Sabha, it is 11 members. That committee deliberates upon the privilege motion, and if it finds merit, it will recommend by way of a report to the speaker as to what action should be taken against the recalcitrant or the person who has committed that particular breach. These are the procedures as far as the breaches are concerned, as the breach of privilege is concerned. Now, we will have to watch and see what happens to the next few breach of privilege motions that are likely to come up in the short run. What is the procedure that Parliament is to follow or the legislature is to follow? With this little background, I will take a little while to, not a little while, to some time to show you and make you more familiar with how our courts have been treating breach of privilege matters. Now, as I told you in section 184, that there are three ostensible privileges in article 184. First is freedom of speech. Second, the right to vote for whomever the person wants to vote. The third is of the report, publication of reports, where nobody can misuse those reports, which are legitimately sought to be part of the publications by Parliament. And so on these three facets, our Supreme Court and our High Courts have dealt with certain case laws. I'll very quickly run through and give you an example of how the law has shaped up since the year 1959. As I told you, the earliest case in British law is of 1452. It has come down over the years, developed into law. In the English law, for where we have derived our major laws, English law goes on a different footing. In England, the sovereignty of Parliament is unquestioned. We have not adopted the English system. We've adopted the federal system, where Constitution is the source of the power and the governance is by three arms: the legislature, the executive, and the judiciary. So the first question was of the year 1958, reported in AIR 1959 Supreme Court 395. This is MSM Sharma versus Dr. Sri Krishna Sinha. Now, MSM Sharma, he was called as Pandit Sharma, was the editor of a newspaper called the Searchlight, very popular newspaper of yesteryears. I don't know, even if today there is a big demand there in Bihar. And Dr. Sri Krishna Sinha was the chief minister of Bihar. Now, in the Searchlight case, what really happened was, there was a certain MLA by name of Mr. N.N. Pandey. There was a furious debate in Parliament where Mr. N.N. Pandey hurled several abuses and strong language against the chief minister. Now, Searchlight, in its enthusiasm, in its journalistic enthusiasm, reported the entire debate and also reported the expunged remarks, the remarks expunged by the speaker in Parliament. And because of this report, a notice of breach of privilege was issued to Mr. MSM Sharma. Now remember, there are privileges for the members of Parliament. And in the course of that the notice being issued, a committee of privileges was appointed by the Bihar Assembly, and they decided to initiate action against Mr. MSM Sharma. Mr. MSM Sharma immediately filed a writ under Article 226 of the Constitution, and noting that he felt that the writ under 226 would be not able to give him sufficient reliefs, he went to the Honorable Supreme Court and filed a writ under Article 32. There he claimed privilege, not privilege. There he claimed a constitutional right under Article 19(1)(a) to say whatever he felt about the proceedings in the legislative assembly. The Honorable Supreme Court dismissed his petition. Why? The Supreme Court said that under Article 184(1), there is a specific freedom of speech, the right granted, a privilege granted to the assembly. That freedom of speech is a higher freedom of speech than Article 19(1)(a). It is a privileged freedom of speech in the sense that anything said and done in assembly or in parliament is something which is prohibited from being used. It's a higher right than the normal right under Article 19(1)(a), and it said that that is a privilege which has been conferred by the Constitution under Article 184 to the Bihar Legislative Assembly, and therefore this was a breach by M.S.M. Sharma, editor of the Searchlight newspaper, and therefore it dismissed the writ petition because it said that you have to read Article 184, you have to read Article 19(1)(a) harmoniously, and since one is a privilege conferred by the Constitution upon the entire House and to that individual member Pandey, that this petition was not maintainable under Article 32, and it dismissed that petition. So remember, there is a play of Article 19(1)(a), and the Supreme Court said that no, the power of speech under Article 184, freedom of speech, prevails over the 19(1)(a) power. So therefore, the Bihar Legislative Assembly withdrew that particular notice, issued a fresh notice. It added some more ingredients to the second notice. The second notice was also challenged by Mr. M.S.M. Sharma, again in the Supreme Court. That case was reported in AIR 1960, page 1186. Again, the Supreme Court dismissed the second writ petition also. And the majority decision in the MSM case, in both the cases, of course, was that 19(1)(a) did not apply for Sharma because the rule of harmonious construction, as I told you, prevailed, and the power under 184(1), which conferred a special kind of a privilege to the members of the assembly, prevailed over 19(1)(a). So these were the two cases. First time the 19(1)(a) angle came into play in the Supreme Court, right? Then you came to another interesting case, which was called as the Special Reference 1 of 1964 under the name of Keshav Singh. This case was reported in AIR 1965 Supreme Court, page 745. Now, in this particular case, what happened was Keshav Singh was an individual and he had some grievance against a member of the Legislative Assembly. And what he did was, he published a pamphlet abusing the MLA. I'm not saying he used bad words, but he used words which, according to the MLA, was a breach of privilege of the MLA's rights. So, Keshav Singh was the man who published the pamphlet, and Keshav Singh got reprimanded by the speaker for a breach of privilege of the MLA for printing the pamphlet, and the speaker committed Keshav Singh to imprisonment of 7 days in the district jail. He said straight away, catch him, put him in jail. He was picked up and sent to jail. Keshav Singh filed a writ petition in the Honorable Allahabad High Court, Lucknow bench, and the matter came up before a division bench, 2 judges, and both the judges, after hearing the matter, felt that Keshav Singh was not a member of the Legislative Assembly. He was an individual outside the Assembly. His rights under Article 19(1)(a) prevailed, and also the High Court felt that Keshav Singh was not given an opportunity to be heard. Principles of natural justice was denied, and therefore they gave an interim bail in a criminal writ petition under Section 491, read with Article 226 that was filed in the Allahabad High Court. What happens then? Very interesting. The Legislative Assembly got livid. It's issued a notice against Keshav Singh, against his advocate, one Mr. Solomon, and the two judges of the Allahabad High Court, and passed a warrant of arrest against the two judges, the advocate and Keshav Singh. The two judges of the Allahabad High Court immediately individually filed writ petitions before the principal the bench of the Allahabad High Court. All 28 judges of the Allahabad High Court convened, took up the petition, and stayed the warrant of arrest by the Allahabad Legislative Assembly. Then what happened? The Allahabad High Court got more infuriated and passed an arrest warrant against all the 28 judges of the Allahabad High Court. It didn't pass a warrant, it contemplated of taking steps. In the meanwhile, the governor of the state informed the president, and the president intervened and under Article 143 of the Constitution made a presidential reference. Now, in the meantime, the Allahabad High Court stepped back and withdrew its warrant of arrest of the two judges, the advocate and Keshav Singh, and said that no, we don't want an arrest, we want them to remain present before us. The Supreme Court intervened in this reference, stayed all that, passed an order of status quo, and are fully deliberating upon the issue, passed an order reading Article 184, 19(1)(a), and held that the entire proceedings against Keshav Singh were bereft of the principles of natural justice, and therefore the assembly could not have issued a warrant of arrest against Keshav Singh. It also held that the warrant of arrest against the advocates, as also against the two judges, was illegal. There came into play two articles of the Constitution, Article 211 and Article 212 of the Constitution. 211 says that no conduct of a judge in court shall be called in question by the Legislative Assembly. 212 says that the High Court shall not enter into any deliberations upon the conduct of the Legislative Assembly in its deliberations, etc. So, reading Articles 211, the High Court said, the Supreme Court felt that the entire action against Keshav Singh was wrong, and therefore it allowed the writ petitions filed by Keshav Singh, the two judges, etc. Another question came into also consideration as to whether the judges could be hauled for contempt, because the Constitution protects the judges in discharge of their respective duties. So that was how Keshav Singh's case was a matter of deliberation by the Honorable Supreme Court. The third interesting case was that of reported in 1972 SCC 272, Tej Kumar Jain versus Neelam Sanjeeva Reddy. Mr. Sanjeeva Reddy was the former president of India, was at the relevant time the Speaker of the House. Now, in the case of Tej Kumar Jain's case, there was a suit filed for damages in respect of certain defamatory statement made by MPs in the House. Now, again, the MPs pleaded that under 105(2) they were privileged, and therefore the MPs could not be sued for damages. Now, what is very important here is that when the parameters of the immunity that members enjoy is that there must be contemporaneous business which is being discussed, about which there must be a litigation, and second, that business must be the business of the House. Correct? Now, take the case of the actor. There was no discussion in the legislature about anything that she did or did not do. Yet there is a contemplation to issue a breach of privilege notice. So there must be some discussion, and that discussion must be the business that the House undertakes at that relevant time. If these ingredients are absent, then such question would not arise. Now we have another very, very interesting case. This is a case of an retired judge of the Honorable Supreme Court of India, Markandeya Kajju. This case is reported in 2017 to SCC, page 384. Now, what happened to Mr. Markandeya Kajju? Mr. Markandeya Kajju wrote 2 articles and on his Facebook. Now, in the 2 articles, he criticized very severely Mahatma Gandhi. And he said Mahatma Gandhi was a person who's brought a lot of harm to the country, and he likened him to some fascist rulers, Nazis or something of that kind. He also criticized Subhash Chandra Bose and said that Subhash Chandra Bose was a person who was well liked by the Japanese, and he became a dictator like the Japanese, etc. Members of Parliament took affront to this criticism and issued a notice to him. He therefore filed an Article 32 petition in the Honorable Supreme Court of India and said that this resolution has to be quashed because it is violating my rights. The Supreme Court said, nothing doing. These are rights where public sentiment has been hurt. Parliament has taken cognizance. It has the right to issue a notice for not for a breach of privilege, but for committal of some kind of a contempt. So therefore, we are certainly going to look into this particular issue, leave it to Parliament to exercise its discretion, and dismiss Mr. Kajju's Article 32 petition. The last of the series in the line of freedom of speech is that of 2014 4 SCC page 473. This is the case of Lokayukt Ripu Sudan versus State of MP. Now, in this particular case, the Lokayukt of Madhya Pradesh state found that the Secretariat of the Madhya Pradesh government had committed some financial irregularities in the construction of a road between Vidhan Bhavan and Vidhan Sadan. He issued notices asking for explanation for the high level of expenditure incurred by the government of Madhya Pradesh. To those notices, there was a challenge by the officers under Article 32, and those officers claimed that they had privilege under 184(3) in other respects as officers, and their rights could not be called in question, and therefore they said that the Lokayukt's notices have to be quashed. This matter was deliberated by the Honorable Supreme Court and said that these are issues which do not protect or grant any privilege to these particular people, and therefore their petitions were dismissed. Now, the constitutional right that was pleaded in Rajaram, in this case of Ripun Sudan, was under 19(1) as well as also under Article 21, right to life. But all these, the Supreme Court rejected, saying that these were not a violation of any of the fundamental rights. This is an inquiry. Go and face the inquiry and go and answer the inquiry. Now, after this, we come to the second part of 184, that is the freedom to vote. So remember, the freedom of speech, the second is the freedom to vote, and the third one is the privilege of parliamentary reports, etc. As far as the freedom to vote is concerned, there is one very, very interesting case law in the case of P.V. Narasimha Rao versus State, reported in 1998, 4 SCC page 626. Please remember, 1991, Narasimha Rao was the Prime Minister and Shri Manmohan Singh was the Finance Minister. These two gentlemen brought about transformation in the Indian economy and really resurrected a country that was financially bankrupt. In 1991, the Congress government came to power, but it came to power with a minority. They were taking supports of small units of different parties. In 1997, there was voting in Parliament, and there was a sting operation undertaken by a TV channel, and four Jharkhand Mukti Morcha MPs, six Janata Dal MPs, and the seventh Janata Dal MP being Mr. Ajit Singh. These 11 people were all caught in a sting operation of accepting money to vote in a particular manner to somehow support the government of Narasimha Rao. Now, when notices were issued by the Committee for Privileges of Parliament, all these 11 members of Parliament challenged the same in the Supreme Court. There was also another 12th person was supposed to have been bribed for another scheme. So all these 11 people were bribed allegedly by a political party that wanted its votes, and the Privileges Committee issued notices for various things: expulsion, disqualification, imprisonment, etc. These were challenged in the Honorable Supreme Court of India. There was a 5-judge bench, and by a split verdict of 3-2, the Supreme Court said that there was no breach of privilege in the case of P.V. Narasimha Rao's case. How did the Supreme Court distinguish that? The bench of Justice Bharucha and Justice Rajendra Babu said that when there is a power of immunity under Article 184(2), where no one shall be made liable for the manner in which he votes, right? In respect of the manner in which he votes, then even if a person votes taking a bribe, defying whatever his party, suppose his party says vote against the government, still the fellow goes, takes a bribe and votes against the government or in favor of the government. Even then, because of the constitutional privilege under 184(2), Justice A.N. Ray was the third judge who disagreed with the other two judges. I think that was Justice J.S. Anand and S.C. Agarwal and J.S. Anand. And on this particular issue of immunity of Parliament, supported Justice Bharucha and Justice Rajendra Babu. Now, what did Justice S.C. Agarwal and Justice Anand say? They said that immunity under 105(2) is not available against liability for an act that precedes the making of a speech or giving of a vote. According to the two learned judges, Justice S.C. Agarwal and Anand, they said that no, the entire conspiracy to the voting, they do not enjoy the immunity, and so therefore they held that 105 does not apply, but the majority judgment prevailed, and therefore the vote take bribes, so to say, is only. But then you have a judgment of Pal versus Speaker. This will not be so relevant for us at this moment. This is on the aspect of expulsion. Can Parliament under Article 105 or 194 have the power of expulsion? The majority judges said yes, Parliament can expel a person. It is within their powers. Now remember, why is this argument coming up? Why is it important? Parliament and legislatures are not courts of law. They are not judicial courts. They are by virtue of a constitutional right. So Parliament is there only because the powers of privilege are there because of the Constitution. But an argument was used that they are not courts, so therefore they cannot expel a person. There is an important aspect here, because if you disqualify a person, he may lose a right to be re-elected, but in expulsion he may come back. But an expulsion is a larger, it has effect on a member, so therefore the deliberation is not really detained us. The last part of Article 184 tells us about parliamentary reports, correct? Now, there are the misuse of parliamentary reports, but there's only one last judgment that I would like to cite. That is 2018 7 SCC page 1. It is the case of Kalpana Mehta versus Union of India. Now, in this particular case, Kalpana Mehta was a member of an NGO, and they filed a public interest litigation complaining that certain vaccines, which was for treatment of cervical cancer amongst majority in age, and therefore it had very strictly trying to oppose. Now, a question came up whether these reports could be used by the NGOs, and government was resisting it, possibly because even it had a report confirming what the NGO was suspecting. Anyway, the majority judgment there said that yes, this is a parliamentary report. It will not have a privilege under 184(2), but something interesting by way of an academic interest came about in that judgment. Justice Chandrachud read into or read that particular issue of allowing parliament reports to be read into various fields of investigations, etc., and said that the constitution is a transformative document, and it has actually shorn off the colonial past, and therefore there should be a more pragmatic and more dynamic reading of the constitution. That was the real academic reasoning.
Recently, with the passing of the farm bills, a number of opposition MPs decided to go on strike on the parliament ground well after the day had been adjourned. Can a notice of privilege be issued in this case? It would be, I would think, the fact of the matter that they went on strike on parliament grounds and well after the day had been adjourned. So would that count as the day itself? Would it count as proceedings in parliament? Because they did it on the grounds of the parliament.
Yeah, my answer would be no. It would not amount to a breach of. It would not amount to a breach of privilege. One, the jurisdiction of the speaker to issue a breach of privilege is circumscribed by the fact that it must be within the hall of parliament, the area of parliament. The speaker's jurisdiction does not travel outside. If the striking members are in the lawns, no, there cannot be a breach of privilege to that extent, to that for this act. Even though it may have taken, the incident happened on the same day, they walked out. If they're on strike outside, it would not amount. If they were within the hall of parliament, the English use, House of Commons use within the chambers of the speaker. Chambers would mean the entire hall of parliament. But the strike takes place outside. Now, they could be hauled up for that person climbing onto the table of the associates. They could be hauled up for tearing the rule book. They could be hauled for coming into the well of the house and disturbing parliament. That could be, but not for this particular case. So therefore, my friends, I think I have come to an end of my lecture. It is a very controversial lecture. I hope by now you are equipped. Whenever breach of privilege matters come up, you should be advising as lawyers to the various people who need advice. And thank you for being so very attentive and spending a Monday evening. Before I sign off, may I thank the PLEA for providing this platform. And it has been a great opportunity of interacting with all of you